Good morning. Happy Friday. Yes, I am recording this on Thursday night. I'm speaking low because that's what I do. This is a video from Discussing Law, trademark, a protege of Chili. There was a hot minute when he was calling himself Dr. Law. I thought that was hilarious. Anyway, he is going to try to rip on Kate, and I figured it's not Chili. I'll roast someone else today.
So today we're talking about applications for entry of default. I guess this will be my follow-up to my video on how to write entry for default. I'm going to talk about many lay people's misunderstanding about this whole thing, and then specifically Jelly's use of this entry of default, and then I think also some supposed alleged attorneys, like Murphy's is also on the same boat. I hear he made a video, but...
I am a supposed alleged attorney who is licensed by the California State Bar in good standing. I am also admitted to practice in front of the Eastern District of California District Court, Federal District Court. That's not a big deal though. You just pay $250 if you're already licensed to practice in California, and you could do that. But yeah, he's talking about lay people. It's kind of weird that he's talking about lay people. It's also kind of weird that he has this disclaimer right here that him and you don't have a attorney-client relationship. He's not an attorney. You know, he is a lay person. I don't understand that, but whatever.
I hope Kate's attorney, no, I hope he isn't smart enough to actually see Jelly's strategy here. All right, so we're going to be watching
Chili's strategy here. I'm going to let the cat out of the bag. Chili's strategy failed. The court, not the clerk, the court denied his entries for default, his request for entries of default, applications for entries of default. I don't know why it took me 3 times to say that, but yeah. So Chili's strategy is a pretty big fat fail, and I guess the court wasn't smart enough to understand it either.
part of Kate's video where she covers Jelly's entry for default.
So this was entered on his amazing, very serious, very professional lawsuit that he has here. So for anyone who's aware,
Yeah, lawsuits are pretty serious, Kate. You should probably start taking it. So
my answer
If they're filed by a clown with no real chance of success, they're not that serious.
was due today. But last week I realized that I probably wasn't going to be able to secure an attorney in time to really, either file a motion to dismiss or a good answer to this. So I
really, last week, this whole time, I mean, either you've been doing nothing, which I don't think is the case, or B, you've been talking to attorneys who won't represent you because they're not stupid and see that you clearly have no case for defense here.
wrote to the court and I said, hey, listen,
What does that mean, have no case for defense? There's always something to do on defense, simply because the prosecution or the plaintiff bears the burden of proof. It's up to the prosecution or the plaintiff, if you're in a criminal or civil case, respectively, to show all the elements of whatever it is they have to show. In a criminal matter, the prosecution has to show every element, each element. They have to prove each element of a crime in order for the defendant to be convicted of that crime. And they have to prove each element of that crime beyond a reasonable doubt. And the defendant's attorney can simply make them do that by offering evidence or witnesses, or well, I guess witnesses are evidence, but by offering evidence and cross-examining the prosecution's witnesses to undermine their credibility and to drop the level of proof that the plaintiffs are offering, to hopefully get it below that threshold level of proof, which in a criminal case would be a beyond the reasonable doubt, and in a civil case is normally preponderance of the evidence, which is just 51% or 50% plus something. So as long as it gets past the tipping point, then the plaintiff wins. If the defense can just keep it, they don't have to prevail. I mean, it could be something like, well, that we the jury think that you didn't meet the, like sometimes, like take for example a situation where there's a counter complaint, cross complaint. Depends on how you want it, who's calling it. Different states and entities call it different things. But anyway, where the two parties are suing each other. The plaintiff is suing the defendant, and the defendant is cross-complaining against the plaintiff. So there is So the plaintiff is a plaintiff and cross-defendant. The defendant is a defendant and a cross-complainant. They may each fail to prove their case. The jury may find for neither of them. The jury may find for both of them. The jury may find for one and not for the other. The complaining party has the burden of proof. So there is no case that a attorney won't take for defense. There's no frivolous defense. You can just make the plaintiff prove every element. And if the plaintiff can't do that, then yay, defense wins.
Yeah, I'm a defendant on this case. I'm trying to find counsel. It's appearing like I may not do it. Can you please extend the time I have the answer? And the judge immediately gave me 30 days.
Yeah, and in interest of right finding on the merits of a case, judges will often do that. Even though you completely broke the rules of the court. Like you're talking about Chili breaking the rules of the court by talking to you directly. Like what rule is that, Kate? Stop making crap up.
I don't think there's a rule that says Kate or that Chili can't talk to Kate directly. But now that Kate has counsel, there was a notice of appearance. Benjamin Wish now represents Kate. Now Chili has to serve things on Benjamin Wish, on Kate's attorney. So, I mean, that's just, but there's nothing that prevents parties from talking to each other unless the court orders that they can't talk to each other. And I have a sneaking suspicion that at some point in time, Joe's going to cross a line and the judge is going to get upset with him and start making things happen. But Kate didn't break any rules.
Yeah, so when you file a motion, you're supposed to confer with the other party, and you never did that.
I don't think she filed a motion. Her letter was construed as a motion. I don't know why the court did that, but the court decided to. And but she just wrote a letter.
Also, basically, you didn't. Well, maybe you did wait till the last minute and did this on purpose. This was your strategy, but it's obvious that the judge hears his motions on Monday. So because the following Monday would have been past your deadline to reply, basically, even though he didn't write it up that way, he didn't just interpret your letter as a motion for extension of time before an ex parte motion for extension of time, which you had no legal right to. You definitely.
Computing extending time. When an act may or must be done within a specified time, the court may, for good cause, extend the time with or without a motion or notice if the court acts or if a request is made before the original time or its extension expires. So, what did she do wrong again? I'm not seeing what she did wrong. I guess in your little world, maybe she did something wrong, but not according to the federal rules of civil procedure.
Did not even specify a reason. If we go back and look at your letter, which I don't have.
Here's her letter. She specified a reason. She said she's working on retaining counsel and she may not be able to do it before the expiration of the time allowed for filing a pleading. That's the reason.
Right here, you just say, I've been trying to find an attorney, I need an extension of time. You didn't say,
No, she did not say that. She said that she's working toward retaining counsel, but may not be able to do so before the expiration of time allowed for filing.
I have been unable to find an attorney, or that I've been trying. Well, I don't think you tried. So.
Well, I mean, it's all fine and dandy to make up what your opponent says and then argue against it. I believe that's called a straw man. I'm not entirely sure. I mean, what do I know? But yeah, that's not what she said. I mean, you could just look at what she said. She said, I am working toward retaining counsel. Apparently that was true because she has since retained counsel. And I may not be able to do so before the expiration of the time allowed for filing responsive pleading. And considering that he filed his notice of appearance on the 12th, she apparently wasn't. So it was a good call on her part. She did right. Kate did good.
And in Shelley's motion, you don't have the right. You guys keep saying, what is this, not Jeremy or whatever? Everyone has the right to an attorney. I think you guys are completely, because you are idiots. you don't have the right to attorney in civil court. It's not a right.
You don't have the right to an attorney in civil court. This is Roa versus Lodi Medical Group from the California Supreme Court. Although the right to be represented by retained counsel in civil actions is not expressly enumerated in the federal or state constitution, our cases have long recognized that constitutional due process guarantee does embrace such a right. This is Department of Labor versus Triplet. The court is looking at whether or not the Supreme Court of the United States is looking at whether or not a restriction on fees that an attorney can get in a black lung case violates the constitutional rights of the client. And besides being constitutionally required, as we've earlier assumed, this is specifically the right to counsel, was also part of the statutory remedy prescribed by Congress. So Congress set up a statute that said you can get counsel in these black lung cases, but it's also constitutionally required. And you can also see that a little bit closer up in here, where the lower court said that the Department of Labor's implementation of the act was unconstitutional because it effectively denied claimants necessary access to counsel. And alternatively, it also denied qualified claimants the procedural safeguards provided by Congress. So it's saying that it's unconstitutional and it also violated the statute. It's unconstitutional because it denied claimants necessary access to counsel. This is Mine Workers versus Illinois Bar Association, another United States Supreme Court case. We hold that freedom of speech, assembly, and petition granted by the First and 14th Amendments gives petitioner the right to hire attorneys on a salary basis to assist its members in the assertion of their legal rights. Not a criminal case. None of these were criminal cases. They were all civil. They were all civil cases. So I'm sorry, what were you saying?
You have a right to counsel in a criminal complaint. They're so friggin' dumb. It just hurts my head. I've been wanting to report on this, but I wanted to wait until after these entry defaults have been terminated.
That's a reasonable request, right? So in the interim,
Yeah, I'm sure it does hurt your head.
so today, actually, the filings have gone over to the attorney, and I have retained counsel. I have an attorney. You should be entering an appearance. If not tomorrow, then early next week.
Which didn't happen.
Oh, I see. It wasn't early. It was midweek. It was Wednesday, not Monday or Tuesday. Oh no.
I think he I don't know. I haven't pulled up the PACER report, but I hear he just did it yesterday.
I'm very happy with the attorney that I picked. I'm not going to get too much into it, but very happy with it. It's a legitimate First Amendment.
And she thinks she needs a First Amendment attorney here again, which I don't know. I guess that's probably what you've been telling the attorneys.
So that, I hear a lot of people say that. The running joke is that I'm a first-year family law attorney because people are like, oh, you're not a criminal attorney. Oh, you're not a constitutional law attorney. Oh, you're not a civil rights attorney. Well, I've represented people for all of those things. And, my State Bar website doesn't limit me to any particular function of law. And you might have noticed that Benjamin Wish, when I did the video the other day, he practices various different kinds of cases. And so, as an attorney in law school, part of what you do is you learn about the Constitution and all the ways it kind of affects, not all the ways, you get a broad overview of it so that you're prepared to go out and take cases about the Constitution. Constitutional rights are a lot of constitutional rights affect a lot of things. Like, in family law, if they're going to take your kids away, you have a constitutional right to an attorney if the court is going to take your, actually, that wouldn't be family law, that would be say guardian or a adoption case. I did an adoption case where the biological father, wanted to oppose it, and he got counsel appointed for him because you have a substantive due process right to family, and if the court is going to take that, if they're going to strip you of your right to be the father of that child, then you get an attorney. I mean, there's a lot of, procedural due process is just in about everything an attorney does, which is from the Constitution. So anyway, I'm kind of going far afield, but you might notice that, like New York Times versus Sullivan, it's a defamation case. It talks a lot about the First Amendment in it. Try reading it one of these times. Defamation case does implicate First Amendment protections. So the court always has to keep the First Amendment in mind when it's dealing with a defamation case, because you're dealing with speech. And that's why you have the whole public figure standard. You have limited public figures. You have matters of public interest that generate different standards based on the First Amendment protections.
Looking for him. Look, I'm just exercising my First Amendment, and this guy just keeps filing lawsuits against me. You went way past the First Amendment.
Cite some sort of authority for that. I haven't seen it. Show me an attorney who's seen it. I don't see it. Good luck. I mean, it's funny. For all his crap about how Kate couldn't find an attorney to represent her because her defense is frivolous, Chili's still pro se. He's still pro se. Chili is still representing himself. So, I mean, who most likely has the frivolous case?
And I look forward to your attorney actually watching the videos and seeing the obvious defamation statements based on supposed facts.
Well, the defamation is obvious, but the facts are supposed? That doesn't make any sense.
Which is what I needed. So, as of, I think it was the 3rd, it was October 3rd, the court did allow me this extension. Here it is now, the 6th. And Chili is applying for entry of default judgment against me. Despite the fact that I have not defaulted because the time that I have to answer this has not expired yet.
Yeah, again, this is dumb, and I don't want to say a lot, but your actual time to reply ends tomorrow, 10:14, and you're not smart enough to know that. And Murby's doesn't smart enough to know that.
Yeah, he doesn't even.
No, I wasn't smart enough to know it either, huh? Well, the court seemed to think that Kate Peters, her answer was due on the 6th. This is from Pacer. Kate Peter was served on 9/15. 9/15. So that's 21 days, the 6th. 15 and 7. And 7 is 14. And 7 is 21. It's the 6th. Is there a court holiday? Come on. No, it's not a holiday. The 6th isn't a holiday. How would you get it to the 14th? How do you get it to the 14th? He said the 14th, right?
Ends tomorrow, 10:14, and you're not smart enough to know that. And Murby's doesn't smart enough to know that.
Yeah.
I'm not smart enough to know that. The court's not smart enough to know that. What am I missing? It's 21 days. What am I missing? Well, How would you get to the... did you think we had it had 30 days? Whoops. 21, that's 28. 29? I thought we had 29 days? I don't know why he thinks he had 29 days. Did you think it's based on the 27th? The date that it was filed? No, because that would be the 18th. I have no idea. Maybe the guy can't count.
He doesn't even want to have a fair legal process at all. No, I think originally, so he's changed it from when he first read out in his stream the other day. He read out, he called, what do you say that, not entitled to...
Anyway, I just want to make it very clear. The court said it was due, her answer was due on 10/6. The way I count it from 9/15, 21 days, the way I count from 9/15 to 21 days is October 6th. It goes from the 9/15 to 9/22 to 9/29 to 10/6. So yeah, I mean, I have no idea. And it's Rule 12A, 1A, small I. No one waived. I don't know what he's talking about.
Frivolous defense. I mean, that's true. That's not frivolous lawsuit, didn't he? Oh, no, your defense can never be frivolous. That is some dystopian storm.
Your defense can never be frivolous? That's hilarious. Yeah, that's why people win lawsuits, because people's defense is always on the merits.
Trooper, like...
Well, so I think our boy is misunderstanding a frivolous claim. There's you could raise frivolous defenses. But just generally defending a lawsuit is not going to be something that's going to get you on the vexatious litigant list. It's raising frivolous complaints, allegations, not defenses. And I think that's what Kate's talking about. I could be wrong.
Like, Darth Vader type shit, like resistance is futile. Thinking of somebody defending themselves whoever he construed as frivolous. That's insane. But this is what he's done.
You're insane.
And he goes on and he says, note the filing motion for extension of the answer complaint was not found to be considered an appearance that required notice before application.
Did our boy just say that she was insane? Our boy just say she was insane. He would not just say she was insane. Would you? Maybe he didn't say it.
For default in Benny v. Pipes, 799F.
And this is funny because she doesn't even read the words. Like, what she ends up doing is just going and Googling. Like, just read the words. Like, they're pretty clear here.
2B 489493, that's started in 1986. So when you look at this case, again, Chile has just completely misunderstood the law because he's a literal fucking idiot.
Or the opposite way around. Kate, you should really, I don't know, stay in your lane.
The facts of the case here were that the...
Pot, meat kettle.
defendants were served with a lawsuit. They asked for an extension. They were granted the extension, and they still didn't answer it anyway. So, I mean, essentially, in order for the default, the time allowed to be by the courts, because they're in charge, not you, would have to expire without you getting an answer before you can get a default judgment. Okay, all right, yeah. This is actually the amazing understanding of the law.
And this is Kate's.
She's right, and you could see it because they requested and were granted extensions of time within Which to respond, so they haven't defaulted. They've been granted the extensions of time. The case is this one right here. The big deal in this case is they actually had 3 extensions of time. They filed 3 extensions of time, and then ultimately the guards failed to answer, and then Benny took their defaults. The motions didn't delay the action significantly, nor prejudice Benny substantially. Benny obtained his defaults within 6 months of filing his complaint. So it extended things out some because they got 3, they filed 3 motions for extensions. But yeah, I mean, this case is not really relevant until she doesn't answer. And then it becomes relevant. then yeah, then it's not a general appearance, so they could take the default. So then, excuse me, then Chile would be able to take the default.
Amazing misunderstanding of the law. Like that's the way that case law works, right? Like the facts have to exactly match the facts. So in the whole Roe v. Wade, right?
The facts don't have to exactly match the facts. You're looking for the general holdings. A lot of times like for Supreme Court cases, there will be the syllabus, and they'll kind of give you an idea generally of what the court held, and that can be useful. But you're looking for general guidance, because you're never going to get the same specific set of facts. I mean, good luck for you if you do. There's always going to be something different. But you're looking for the general principles behind what the court is saying. That's how you get from, like from my video the other day, where Chile's saying, oh, you can't tell me to go back in the car, and he was saying that based on Philadelphia or Pennsylvania versus Mims. I don't know why I said Philadelphia there. I'm tired. I'm sorry. So Pennsylvania versus Mims, the court was dealing with pulling someone out of a car. Can the cop take someone out of a car? The general principle was you're detained. It doesn't really make that much of a difference whether or not you're sitting in your car while you're detained or you're sitting on the side of the road detained. And officers can make those decisions based on officer safety, and it doesn't have to be a particularized thing. It's just generally. And then you apply that to a situation where the cop is telling you to get in the car. Well, use those same kinds of general principles. You're detained, so it's not that big of a deal whether you're detained in the car or out of the car. So the cop can, for officer safety, can say, get in the car. That's the way it works.
You only have the right to have abortion in the first term if the name of the doctor is Wade. No one else has the right to do that. That's just totally dumb.
Yeah, I mean, setting up those straw men and then knocking them down, boy, that is dumb.
So I'm going to break down this in more detail in just a minute.
I'm glad that we got that there. Right. So that was good. Okay, we have almost 100 people here. And that was the time to start, I think. So I'm going to show you these documents. And hold on. All right, I'm going to show you these documents. I'm not going to.
So I don't think the rest of the video is necessary. What we're going to do is we're going to look at the comments, some of the comments from this video also.
Oh, well, we're not going to deal with what Kate says. Now we're going to look at comments. Okay.
So Anne, not a very lovely person who comments incessantly.
I think Ann is a pretty nice person.
And apparently has nothing better to do than to Google stuff and then think she's an expert. What is that?
Who else? Who else here is just a Googler who thinks he's an expert? Could it be you, Dr. Law?
The Dunning-Kruger. So she says, I read the Benny v. Pipes case, and in that case, the defendant obtained 2 extensions and then never responded, which certainly isn't the case here. Once again, Chile is showing that he doesn't comprehend what he's reading. Again, it doesn't matter. So in fact, you kind of point out what he was saying. So the defendant obtained 2 extensions. That sounds familiar. I think that was,
And then never responded. The big deal was that it was 3 extensions, but never responded. Third motion. And ultimately the guards failed to answer. 3 motions. And then failed to respond.
alleged in the video that note that filing motion for an extension of time. That's completely irrelevant.
She didn't file a motion for an extension of time.
So Ian's saying, I am a scholar of poop, maybe, says Jaleel simply Googles things like court case plus extension and then references the first thing that comes up without even reading it. Yeah, right, poop scholar, totally nailed it. Shannon Swanson says, I read through the court cases in his defamation lawsuit, and they're all the same way. I don't remember if he mentioned court cases in it because it really doesn't matter. I mean, that's really not the place to do that, is in the complaint. It's all about facts and elements and relief, that's all. And you're too dumb to know that. So he picks sentences out of the case and thinks it applies. Most of the cases just allow people to continue with the suit, and one of them actually supports the opposite of what he's claiming. I don't know. So apparently Shannon is doing her Google legal analysis of the original complaint. So Thomas Becker says, Benny v. Pipes was a completely different thing. Prison guard were handed paper documents, crumpled them up, and then threw them away. Yeah, because Kate didn't do that, right? She didn't tear up documents and throw them away. Oh, she did, by the way, for those who think I'm not being sarcastic. And Ann Valgard says, they also received several extensions. And again, it's not relevant, right? All the facts don't have to match. It's not how case law works. So Ann says, they also received several extensions so they could file the responses, but never filed anything. Ignored it completely, and then the court granted the judgment. That's kind of where we're at right now, right? So Kate filed an extension and has not filed a response, ever.
Yeah, but see, the thing in Benny is that after the extensions ran out, the guard still never filed an answer. Kate, her extension has not run out. So it's not applicable yet because it only becomes applicable once her extension runs out.
Ever has she filed a response? And then Ba'a must be a sheep. Oh, that makes completely sense. He's a sheep. Says absolutely. And after filing 3 requests for such time as defense, never responded to the complaint. The reason why order default was entered. Shelley's diluted motion was filed prematurely on the last day Kate had to answer. You guys need to do your math right. And actually, if you guys don't even want to read on how to calculate time in the legal system, there are many calculators online. Just Google it. And also,
And there's also Rule 6 that's specifically called computing and extending time.
disregard the court's order granting Kate 30 additional days to respond. So as far as I know, Shelley had not yet received even a copy of Kate's. Oh, wait. Actually, we're going to get into that in a minute. So he did receive her letter. He had not received an order on that letter yet. So.
Well, Chile, to the best of my knowledge, has not signed up for the electronic service from the court, which he doesn't have to pay for because he's a participant to the case. He can get documents. It goes through Pacer still. At least I think it does. I've never been pro se. For the attorneys, it comes through Pacer, and you can download a copy of it. Yay! And they don't charge you for it because you're the attorney on the case, and so there you go. If you're not the attorney on the case, then you have to pay for it. So I'm assuming it would work that way for Chile as well. So it's really Chile's fault that he's not getting these things because she did it the same day, and it was 3 days after. 3 days after she made the order. 3 days after she made the order that Chile filed his application for entry of default. It's kind of weird. I mean, he doesn't have to. He can rely on getting the mail, but that's going to screw him. I mean, he's going to waste a lot of time and effort because he's just not accepting the electronic service.
The whole reason. All right, so let's go back to.
And why do we want to excuse him for doing that? Oh, well, he's too lazy or stupid to sign up for the electronic service, so he didn't get the court's order yet. Well, oh, okay. Congratulations, you played yourself.
Benny v. Pipes, all right? Note that filing motions for an extension of time to answer the complaint, right? So he had received Kate's letter, was not found to be considered an appearance that required notice before application for default. So what Chile...
Right. But it's still not applicable because the court granted the extension. So this argument is stupid because this is an application to the clerk, and the clerk's not going to read that. The only reason why the judge read it is because the clerk's like, we got these, and maybe we are not understanding your order because you've already extended the time, so here you go, Judge, what do you want to do with it?
Here is saying, and it's plain English. I don't know why you stupid people. Oh, sorry, because you're stupid. That makes sense. To understand it is, Chile had received a letter. Normally, if the other party had appeared, you would need to give notice before you did application of default. But Chile realized that there was a loophole there, or whoever his attorney is. I'm guessing he has an attorney right now, helping him at least. So,
if he had an attorney helping him, his attorney would have realized that extending time, that letter was enough to extend the time. The court is gonna grant it. Without even thinking about it, the court's gonna grant it. You just expect the court to grant it.
He was like, well, I don't want to have to send notice before I file my entry for default because that's going to delay things. Oh, there's this loophole. So as it turns out, Kate didn't file an appearance by just filing a motion for an extension. So he can file his application for entry of default without doing notice first. So that's the case that decides that, many v. Pipes. And I've seen some people also say what's the difference here?
It doesn't, again, it doesn't, whatever. Like, okay. It doesn't decide it. It is, at best, it is best, why am I blanking on the words? It's not stare decisis. It's persuasive. It's persuasive at best. But if you look at Benny, they do a calculation in there. They try to figure out whether or not, because the guards were arguing that they had made general appearances, and where was it? They go into analysis. Here we go. An appearance ordinarily is an overt act by which the party comes into court and submits to the jurisdiction of the court. There's an analysis the court goes through, looking at these various motions that Benny filed. Motions. Kate didn't file a motion. The guards and Benny filed motions. Now, why did they file motions? Well, they filed motions because the time lapsed, and then they filed the motion, right? So the court is going to have to look at whatever was sent. In this case, it was a letter. A letter is obviously not a general appearance. It's a letter, as opposed to a motion, which is different than a letter. Because it has to be made on a motion after the time has expired. It can be made with a motion before the time expires, but it has to be made on a motion after. Now, motion is different than without a motion. Kate did it without a motion. Benny is not applicable.
Okay, learn how to interpret that. So, let's go into that. So there's this document, that kind of breaks down this, that I recommend you all Google and download. It's by the Georgetown University Law Center. It says, which court is binding versus persuasive cases? Let's go down the bottom. All right, so federal issue and federal district, let's look at the headings. So state or federal issue, which court are you in? Binding authority and the persuasive authority. All right, so we're a federal issue in federal circuit court. Yep, that's where we're at. And then, actually, yeah, it's a federal issue. It's because a lot of his other things, right, and his lawsuit are going to be state issues. So look, persuasive authority, all federal courts, other state courts, interpretation from the state's highest court. So don't be surprised if Chile starts citing cases from California, and you guys are going to be like, oh, that's them, but it's binding authority. So here we are. So federal issue in federal district court. Binding authority is via a citation to a Supreme Court decision or a federal circuit court in the circuit where the district court is, right? So he cited a Ninth Circuit court case. Why is that? Probably because that hasn't been ruled on in a First Circuit court yet. It eventually will be. Maybe if Chile's court case goes all the way to appeals, then it'll, or to the Supreme Court, then we'll be good, right? And then what people will do is in the First Circuit they'll cite Chile's case, and then when you read Chile's case, it'll say it originally cites the Ninth Circuit case. So it's kind of just like a big old loop. Until that happens, it's persuasive authority, and Chile's not responsible to specify that because you know what? The judge understands how that works. So other federal circuit courts are persuasive, federal district courts are persuasive, and all state courts. So who is dumb? It's all of you friggin' idiots who should really stay in your lane. And it sounds like Murby needs to start doing that as well. If you're
I probably do need to start learning to stay in my lane.
relying on any of these law experts that are in the troll farm, okay, you are in for a world of pain.
Yeah, because once again, Chile's applications for entry of default were denied. So, okay.
So, I think that's all I had. Again, your last day for reply is today. So,
Your last day for reply was 30 days after the 6th. So, it was 30 days after the 6th. So 1, 2, 3, 4, 28, 29, 30. So then it would go to the 7th, because that is the next court day, since it fell on the time is extended to the first accessible day that is not a Saturday, Sunday, or legal holiday. So from there it'd be 1, 2, 3, 4, that's 28, 29, 30 would be the 5th, which is Saturday, 6th Sunday, 7th Monday. So it'd be due Monday. Monday, November 7th. And what did the court come up with? Adams is due November 7th. And, well, you could see his. So his file was filed on his was due on the 7th, right? Let's see. Oh wait, no, I have it up on Pacer. His was due on the 7th. So extended 29 days from the 7th. 1, 2, 3, 4. So that's 28, that's 29, and then you go 2 more forward to get it to the Monday, and that's the 7th. That's how it works.
It doesn't look like it's going to happen, so let's see how the judge rules.
Well, the judge ruled. Anyway, thanks for watching. Have a great day.